Well, welcome everyone. Welcome to everyone in the room, and also welcome to all of you on Zoom that are joining us today. I think we have how many on Zoom today? 200 signups, so we've got a robust participation. So my name is Cynthia Jones. I am the program chair for the 9th Judicial Circuit Historical Society, and we are so pleased to partner with the Berkeley Judicial Institute that really organized this program. We are just happy to be part of it. And I would be remiss if I did not thank our Seattle University School of Law student volunteers, Christian and April in the back. Thank you very much. And then I have to say, one of the most important people in the room, it's making all of this possible, is Tony Duck. He's in the back of the room. Thank you, Tony. So we have a lot of partners today. I'm going to keep my intro very brief, and it's a testament to how much the concern there is over an independent judiciary today. So without further ado, I'm welcoming you for the NJCHS, and it is our mission to preserve history, to educate about history on the independence of the judiciary and more. And our other sponsors are the M. Margaret McEwen Federal Bar Association. You're going to hear from the president, Mike Wampold, in a moment. But first, it is the court that is funding the wine and cheese reception, which we invite you to join after. So we'd like to welcome Chief Judge David Estudillo to give some welcome remarks. Thank you.
Hey, good afternoon, everyone. And I'm going to be brief because I really want us to get to our panelists here. We have a great program, of course. Stress and duress, past and present challenges to the judicial branch. As Cynthia mentioned, thank you to all of the sponsors. In particular, of course, UC Berkeley School of Law and its Berkeley Judicial Institute. We also want to thank the other co-sponsors, the Federal Bar Association for Northern District, California, the 9th Judicial Circuit Historical Society, the Washington chapter of the American Board of Trial Advocates, and the Western District of Washington's M3 Federal Bar Association. Our distinguished guests have traveled here to the beautiful Pacific Northwest, and somebody brought some sunshine, and sounds like somebody also, or looks like somebody also brought some heat, because it's a little warm out here for some of us. So we appreciate that. We appreciate that. So today's panel is going to provide some insights into the historical and current challenges facing the judiciary. As I believe Cynthia mentioned, independent judiciary, it is fundamental to our society and to our democracy. And an attack on the independence of the judiciary obviously is an attack on the rule of law. And an attack on the rule of law basically means we fall into something that we don't want to fall into. And I won't go there other than we must be careful to protect the independence of the judiciary and, of course, the rule of law. So with that, again, I was going to be brief, and I'm going to hand it over to Mike Wampold, president of the M3 Federal Bar Association, and he's going to give some introductory remarks as well.
Thank you all. And on behalf of the M. Margaret McEwen Bar Association, welcome. And thank you so much for attending. And I want to really thank our panel, because this is an incredible panel. You can see even on a hot day, a lot of people showed up in person and more online to see all of you. And we're really excited about this very important talk at this very important juncture in history. And I'm very proud of the M. Margaret McEwen Bar Association in conjunction with all these other great organizations putting on programming like this. And a lot of it is because of Cynthia. So let's all give it up for Cynthia, has helped organize all this. And this is one of 20 programs that our Bar Association has put on or co-sponsored, and a lot of it behind the scenes with Cynthia's doing. So thank you so much to her. And with that, I'm going to turn it over to Robin Lipsky. Thank you all.
Okay, and luckily I'm the last one. So, and then we can turn it over to the panel. I am Robin Lipsky, and I am one of the program planners at Berkeley Judicial Institute. BJI's mission is to promote and support an ethical, resilient, and independent judiciary. We're so excited to have you all here today, both in person and for those of you joining us over Zoom. I'm very excited to hear from our panel. I will just take a moment, though, to urge you to sign up for Berkeley Judicial Institute's newsletter so they can hear about our future programming. We do a lot of great work as well. And I will introduce very briefly the executive director of the Berkeley Judicial Institute, Judge Jeremy Fogel, who you may have seen or heard from recently in any number of newspapers or news programs as he speaks on a number of topics and issues related to the courts, very much including today's topic. Judge Fogel deserves a much lengthier introduction than I will give him now. In the interest of time, let me just highlight that prior to his appointment at Berkeley, he served as director of the Federal Judicial Center in Washington, D.C., as a United States District Judge for the Northern District of California, and as a judge on the Santa Clara Superior and Municipal Courts. Judge Fogel has also served as a lecturer at Stanford Law School for the College of Continuing Judicial Legal Studies for California Judicial College, and as a faculty member for legal exchanges with approximately 20 foreign countries. He received his BA from Stanford and his JD from Harvard. I think we've heard of that. It's still his place, right? And among his major areas of interest are judicial ethics, judicial administration, judicial decision-making, including effective ways to teach judges about unconscious bias and impact of emotion, and judicial wellness, a topic near and dear to his heart. But like this is, I will turn everything over to Judge Fogel. Thank you.
Thank you. Thank you, Robin. And Robin, thank you for everything you've done to make today happen too, because it wouldn't have happened without you. And I want to just call that out. And I can't resist this. I shouldn't, because I'm supposed to be a moderator and I'm supposed to be neutral. I went to Harvard Law School. You heard that from Robin, not from me. But the point is that I'm not a very good alum. I've never really given much money. I've never really cared too much about what goes on there. I just have to say that. And that has all been different for the last 6 months. I think they're the greatest institution in the world right now. So I just have to say that because it touches on some themes we're going to talk about, kind of like how we got to where we are and where we are. And I'm really, really happy to have these three people with me. I think if I were going to put together sort of a dream panel to talk about the history of the U.S. judiciary and judicial independence and all of the themes that have become so prominent in our minds in 2025, I really would not imagine a much better group than this. And I'll start over here. And I was teasing them about this. They're both from North Carolina. One is from UNC and one is from Duke. And normally you wouldn't have them sitting together like this. There would be.
It's okay.
We're good.
There would be, stank guys going both ways. But anyway, they're good friends, and they're really. I'm just so happy to have both of them. They're two of our most prominent legal historians, and it's a special skill to be a good legal historian. I think you have to really kind of get the big trends and the big messages, and I think we're really fortunate to have both of these professors with us. So Michael Gerhardt from UNC and Marin Levy from Duke. And you'll hear from both of them on different parts of our judicial history and how the issues we're dealing with today around independent judiciary and judicial independence and threats against the judiciary, all of these very present day topics, how they are rooted in 250 years of our nation's history. And then to my right is Judge Michelle Childs, who is a judge on the DC Circuit. Previously was a judge on the District Court in South Carolina. And she has a tremendous record of working on behalf of judges. She's the immediate past president of the Federal Judges Association, very active in the ABA and all of the judicial groups that work through the ABA. Just a real prominent and effective advocate for judges. And I would be remiss if I didn't say she really worked hard to get here. She was going to appear by Zoom until She told us a couple days ago that, no, I'm going to find a way to get here, even if it involves taking a red eye. So I just want to personally thank Judge Childs for going out of her way to be part of this group, because it's just better in person. And as you'll see, she's really better in person. So that's our panel. And I kind of got a little bit arbitrary in thinking about where to start, but what we'll do is that each of the panelists will open up a topic, and then we'll talk among ourselves, and hopefully we'll have some time for questions at the end. So I'm going to start with Professor Levy. So, back in 1789, we had a constitutional convention, and there were it was not smooth. There were debates about a lot of things, and the one that we hear about more often is that, debates about slavery and debates about things like that. But there was actually a very robust debate about the role of the judiciary vis-a-vis the other branches. So maybe we should start there, and we'll pick it up from there.
Sure. Well, thank you so much, Judge Fogel. Thanks everyone for being here. It's an honor to get to be alongside these terrific panelists. Am I allowed to do that? Okay, I was told not to touch. I'm a rule follower. Okay, is that a little bit better? There we go. Okay, so the thought is to talk a little bit about the history of judicial independence, and maybe with an eye towards impeachment, because that's something, of course, that's been coming up in the news recently. So I thought I'd do both at the same time. And actually, I'll start a little bit before the convention, going back to the Declaration of Independence. So, I think when we talk about the Declaration, so many of us think about famous lines, we hold these truths to be self-evident, that all men are created equal. It's easy to forget that language actually really comes before a set of grievances against the crown, right? We have these 27 grievances that are lodged against the king. And one of those grievances had to do with the role of judges. So in particular, there was a concern at the time that the judges were dependent on the king's will for the tenure of their offices, and of course, for the payment of their salaries. Now, anyone who looks at an arrangement like that can see what the problem is right away. So Blackstone had famously written in his commentaries not too long before all of this. So if the judiciary were to be joined with the executive, it might soon be inclined to pronounce that law which would be most agreeable to the prince or his officers. Right. So right out of the gate, we have this concern. And so it's not surprising then that when we get to the convention, this topic of the need for an independent judiciary came out quite forcefully. And this is something that's then recounted by folks like Alexander Hamilton. We get this in Federalist 78, right? The need for an independent judiciary. And so then the question becomes, if we're to have that, how do we actually assure it? And we all know the answer to that. Of course, we're to find that in Article 3 of the Constitution with a few key provisions. So in particular, as we all know, so federal judges shall hold their offices in good behavior, and they shall receive salaries which shall not be diminished during their continuance in office. Right. So right away, we see through the text of the Constitution a response to the arrangement that had existed for the colonies beforehand. Now, obviously, as we know, this didn't mean that there was no way to remove a judge should there be some sort of problem. That's where impeachment comes in, and federal judges are treated just like other federal officers for those purposes. The idea being that you can remove a judge, of course, after impeachment and then conviction of treason, bribery, or other high crimes and misdemeanors. So if you want, I can talk just a little bit about some of those first episodes with impeachment, or I can also hold off, whatever you think, Judge.
No, I think that would, that this is, and this comes up, you hear it in the rhetoric today. How can a district judge tell the president what he can't do? That I've heard that said, but that was actually something that the founders debated.
Yes.
Was whether that could be done.
No, absolutely. And Mike, I don't know if you want to jump in on some of this too.
Sure. But I hope will allow me to also express my gratitude for being here today. And I hope Judge Childs will forgive me by saying it's good to be in Washington. And I prefer this Washington. But that's another story. So I certainly agree with what Marina said. I just want to maybe add a couple
Sure.
other factors, which I think will help sort of provide context for our discussion. Marin's absolutely right about the Declaration of Independence. It's often overlooked, but the Declaration of Independence includes 27 articles of impeachment against the king. That was no accident. Impeachment was central, ultimately, to the founding of the United States. And one reason why the framers who wrote the Declaration of Independence put their arguments and grievances in the form of impeachment articles is because they understood, having lived with the frustration, that in England, the only person not subject to impeachment was the king. So clearly, even before we were a republic, there was a commitment to ensure that no one would be above the law. That in fact, the president might have a great deal of power, but the president would be subject to impeachment. And almost all the discussion about impeachment in the Constitutional Convention was about presidential impeachment. But to fast forward more to post-ratification, I'll just mention, as probably all of you know, we've had 21 different people impeached by the House of Representatives. Only 8 have been convicted and removed. All 8 were federal judges. There are a few different reasons why we end up with figures like that. One of them is the requirement for conviction and removal is 2/3, at least 2/3 of the Senate, which, by the way, is really hard to achieve. You can't get senators to agree it's Monday, much less on something as monumental as, removing a president or something else, removing even a judge. I think the second reason why we get a statistic like that is because federal judges are probably, and I don't mean, this is going to sound like it's a criticism. In fact, it's not. It's just the opposite of that. Federal judges are not political actors. And the thing about impeachment is it's a political process. So the people that are most likely to be vulnerable to that are the people that are not political, may have trouble sort of mustering the political support. But the other thing about it is the federal judges, I think, also have to deal with the problem that because it's all political, that means it's a language, it's a rhetoric, it's a context, it's a dynamic they don't have much expertise in.
Well, and that's really interesting because it's certainly true. But so of the 8 federal judges who were convicted and removed, every one of them was the basis for the impeachment and removal was committing a crime.
Exactly right.
I made a list of kind of those just to kind of give you an idea, because I think people get in kind of this cloud and saying, well, what actually is impeachable, or who actually got convicted, such that you would want to know the type and just how high that is.
Yeah.
And so I took the time to do that. And so charges of mental instability and intoxication on the bench, refusing to hold court, waging a war against the U.S. government, charges of improper business relationship with the litigants, charges of favoritism in the appointment of bankruptcy receivers and practicing law while sitting as a judge, charges of income tax evasion and of remaining on the bench following the criminal conviction, charges of perjury and conspiring to solicit a bribe, and then also charges of accepting bribes and making false statements under penalty of perjury, just to give you an idea of what actually sticks.
So this was not, they ruled against me on a TRO application. Which, yeah, go ahead.
No, sorry, Judge.
No, I was going to say that, when you look at it, and thank you, Michelle, for bringing that up, because when you look at the actual particulars of these removals, and, none of these people should have been federal judges. I mean, there's not a lot of political finesse here.
That's right.
But there was a very important precedent, and Marin, I'm going to ask you to talk about it.
Sure.
So there is a guy named Samuel Chase who was on the Supreme Court at the beginning of the 19th century. And he was a Federalist, and the Jeffersonians had swept the election. They had supermajorities in both houses, and they didn't like Justice Chase's decisions. So what happened?
Yeah. And
Okay. Yeah. Okay. Thank you. Not the first time. Thank you.
We're going to have to start over. Sorry about that.
we wouldn't do that to you. So actually I'm going to take a little bit of license here and take one step back from that even, because I think it's helpful to look at the very first impeachment where we get an actual conviction. This is with Judge John Pickering. Happens early on in the country's history. So John Pickering was a district judge from New Hampshire. He was nominated by President Washington. So we're going, of course, back to the beginning. So he receives his commission soon after that. So we're talking 1795. But within a few years, Judge Pickering starts to show some pretty significant signs of cognitive decline. And I mean, to the point where his staff even starts writing to other judges in the area and saying, can you assist us in some way? And a judge is sent in to take over Judge Pickering's workload for a little bit. I mean, this is how bad things had gotten. So the House votes to impeach him in 1803. But this was not without some controversy. So despite the fact that it was such a clear case, I think from the outside, you have Federalists arguing that Judge Pickering had committed neither high crimes nor misdemeanors, and that this was really being politically motivated. I think the fact that he was so clearly failing, though, made this a pretty easy case from the outside. And ultimately, the Senate does vote to convict him, and he's removed from office in 1804. So that's the first case that we get. And it's right on the heels of that, of course, that we get the impeachment of Justice Chase. So again, the history that Judge Fogel gave, we have this ardent supporter of the Federalists, and he was not shy about that fact. It is hard to imagine something quite like this today, I think. The idea that a justice of the Supreme Court would actually be openly campaigning for a presidential candidate. So he's openly in support of John Adams. This is in the election of 1800. And there's a bit more. So fast forward just a few years, 1803, he ends up giving a grand jury instruction that was quite critical at the time of the repeal of the Judiciary Act of 1801. So, I mean, he's really getting into the politics of the day and not, as we said, being shy about it. Word of all this reaches President Jefferson, who is not amused. And he right away writes to members of the House and basically asks them to intervene, right? This is what impeachment is for. You all should go out and use it. But what follows, and I think is really important for the country because it helps to establish the threshold, the very high threshold that we've used ever since then when thinking about impeachment of federal judges. So Chase himself actually mounted a defense. He asked for more time to do so, and his defense was quite lengthy. He wrote out something, I think it was about 100 pages. It took over 3.5 hours to read. And he's making his case, and he says, I think these words are important today, a party in power might, under some kind of pretext, destroy any judge who might happen to say something capable of being construed by them into a political opinion adverse to their own system. So the idea being, if you're looking at me because I've said something, perhaps, I shouldn't have on the bench, right? This is now a standard that could be used to take anybody off the bench. And it really has to be that we're looking to something like an indictable offense. And the Senate, of course, eventually votes to acquit. So I think that ended up being a really important kind of high watermark that we've respected ever since. And that's, I think, one of the reasons why we look and we see there haven't actually been that many convictions.
So I will add, if it's okay,
Please.
that the impeachments of John Pickering and Samuel Chase actually took place pretty much the same time.
Yeah.
And that was no accident. You probably all learned this in law school or forgotten it by now. But in the background of Marbury versus Madison is the fact that it was the 1800 presidential election, and Adams and Jefferson hated each other, and Adams did a few things that ticked him off. Fair to say. Once Jefferson gets in office, one of the first things he and Madison think about is, let's start trying to impeach the Federalists. Pickering, as Marin says, was it turned out to be a harder case than I think the Jeffersonian thought it would be, because they just thought, okay, we've got the numbers, we should be able to just toss them out. But the problem was, as Marin said, is that he was degrading mentally. There's also some suggestion he was drinking too much. Judge Pickering's son pled with people in Congress at the time, don't do this because this is not the right remedy. My dad basically needs to be in like a hospital or something. I mean, that's the appropriate thing. So Pickering gets convicted, Chase does not. But what they also have in common is that they were selected. They're the only two attempts in our history thus far. The judges were singled out for their political, for the political party that they belong to, and for political reasons directed at their opinions. Jefferson and Madison also, of course, as you know, threatened Marshall with impeachment during Marbury versus Madison. So a lot of people are thinking about impeachment at the time. The last thing I'll say, if I may, is we haven't talked about the definition of high crimes and misdemeanors. So let me just throw that out, if I could, really fast. That language was selected after a lot of thought. And basically, what high crimes refer to are misconduct that seriously injures the republic. It doesn't have to be an indictable crime, but it might be easier if there were indictable crime. And then misdemeanors are acts that are done to facilitate those crimes. That's the basic definition. In no way does either Pickering or Chase fit into the framers' plan. In fact, the last thing I'll say about Chase is Chief Justice Rehnquist wrote, I think, a really good book about the impeachments of Andrew Johnson and Samuel Chase. And one thing that Chief Justice Rehnquist said is the lesson that is learned from Chase's acquittal is that judges should not be impeached and removed for their opinions. That has been a precedent we have followed, which now introduces the whole concept of a precedent. And a lot of what we're going to be talking about next and for the rest of the day are what kinds of precedents are being set.
Yeah, thank you, Michael. That's really, really helpful. So most of you know the Chief Justice Roberts, issued a statement after the current round of impeachment threats saying we don't do that, that's not our country's history. And he did not call out Justice Chase by name, but he clearly was talking about that we have a history, we have precedent that we don't impeach judges because of their opinions. And I don't know if the chief's been in the news a lot lately. I'll say one thing about him, and I had the privilege of working closely with him at the FJC. He's a very cautious person, and he does not say things like that very often. And you really got to go some to get him to issue a public statement saying something like that. It's just not, I'm just sort of imagining what was going on behind the scenes and in his mind before that came out. But he thought that it was just really an important thing to say. This is just not how we do things. And of course, Chief Justice Rehnquist was hardly a wild-eyed liberal. So, it was interesting that they're both pushing back on that. And I also think, and this sort of goes to if anyone ever read Profiles in Courage, President Kennedy's book, he talked about the people in the Senate who did not vote to convict Andrew Johnson. That was a profile in Courage. Well, you go back and look at the impeachment of Chase. As I said, the Democrat Republicans, Jefferson's party, had a supermajority in the Senate. And there were six of them who wouldn't vote to get rid of Chief Justice Chase. So that's how robust this tradition is. So, Maureen, you want to say anything else before we move on to Michael's additional history?
No, I'm ready for the additional history.
Yeah, wow. I can't wait to hear it.
Yeah.
So I've been asked to sort of introduce the idea of different eras.
Yeah.
Throughout our history.
Not Taylor Swift eras, though.
No. Yeah, I need to speak more clearly. Different eras in which the nation's experienced, and the federal judges in particular have experienced political retaliation in one form or another for their decisions. I have roughly sketched 4 or 5 such periods. So I'm going to ask each of you, if you don't mind, to address whichever one of these you want to. The first is something we've already talked about, the Jeffersonian era. And there was a lot of fights that were not just about done with respect to impeachment, fights over nominations. There are a lot of other things that happened during that period of time, which are all helping to shape the Constitution as we know it today. The second era is the Lochner period, but also closely related to that is the New Deal era. Having written a biography of FDR not too long ago, I have lived through that, so to speak. And so relearned about that era and the threats that were made by him, among others, against judges based on their decisions. And then, of course, besides the current era, there's the civil rights era. And there's a lot to be said about that, of course. So Judge Childs, I'm going to start with you if I could, and then we'll just work our way down the.
Sure. I mean, obviously, with respect to the civil rights era, when you're dealing with all of the cases with respect to education and desegregation of the schools, all deliberate speed. It didn't happen, correct? I mean, it was about 10 years or so before people were actually abiding by these rules. And at that time, judges were threatened with bombs, crosses in their yards, further threats with family members. But then there was a time that the orders actually got abided by, but it took the executive branch to actually insist on those orders being abided by. But that's not what we're having now. We actually have the executive branch being part of the issue with respect to not obeying the orders. And it's putting the judges in quite a predicament, if you will, because we're looking at the enforceability potentially of the orders at this time.
Right. But the judges in the civil rights era certainly got plenty of grief from, I mean, the judges who actually tried to enforce.
Yes, it was very unpopular and very dangerous.
Yeah. And judges were either threatened with death, and there was even one assassination. So, well, I'll pick President Roosevelt in the New Deal. And I think it's important to do that because this is not just a phenomenon of the current era. It's not a blue and red thing. I mean, there have been different times in our nation's history where the judiciary has been attacked from one side or the other, and I think it's important to say that. I mean, the New Deal, there was a depression and things were in really bad shape in the country, and President Roosevelt did things that had never been done before, very aggressive changes. I mean, some familiarity even today, the changes in departments and changes in the way government worked and things like that. And the Supreme Court kept overruling him and blocking what he did. All of his signature legislation got blocked by the courts, not all of it, but most of it. And he was furious and he wanted to find some way around it. And he came up with a court packing scheme to increase the size of the court so he could appoint more justices. So that was a time when the executive was very much at war with the courts. There was a retirement or a death, I forget which, and there was an appointment made like in 1937 or 38, which resulted in a 5-4 majority in favor of Roosevelt's viewpoint, and it was called, the stitch in time or the switch in time saves 9. That the court packing scheme basically did not succeed because there was another pro-Roosevelt justice who was appointed to the court. So, we've been in territory like this before in some ways.
Right.
Sure. I feel like I'm getting cold called a little bit here.
Oh, sorry.
No, I love it.
You can talk to us about the Lochner case.
I'm pretty confident.
So maybe I'll make 2 points if that's okay. So to piggyback off of the civil rights discussion and to bring us back to the initial observations about impeachment. So, I think everyone here is familiar with the John Birch Society's famous billboards that you would see in the wake of Brown v. Board of Education, impeach Earl Warren and this sort of thing, right? That happened several years after Brown, but it was clearly in response to Brown. So it's not a new phenomenon what we're seeing today, these calls for impeachment. And in fact, I would say we even had calls coming from inside the House, as it were. So if you look like the Georgia House, actually, right after Brown passed a resolution calling for the impeachment of Warren and 5 other justices for betraying the Constitution. I mean, amazing to think about that, right? Political actors actually at that moment, again, this was in the state of Georgia, calling for such a thing. Again, I bring that up because I think helpful to see that the context of what's happening today. The only other observation I would make is I think it's useful to group these episodes as we've been doing, but worth also observing that just over time, we have seen responses to particular decisions, judges receiving death threats and other forms of intimidation. And we see this with things like Judge Irving Kaufman in New York following the trial with the Rosenbergs, right, famously found guilty for espionage. He sentences them to death. And then for the rest of his career, he faced death threats and both at home and in chambers. Obviously, there was a particular fever pitch after Roe v. Wade. Harry Blackmun, right, who authored the majority opinion in that case, famously faced death threats in the aftermath of that. As we know, quite recently, Justice Kavanaugh faced an assassination attempt because of his role in the Dobbs decision. In fact, explicitly, the person who attempted to commit that crime said that he was targeting the justice because of the leaked opinion, and he thought that this was an important response. So, I mean, I think, again, we can focus on these particular points in time, but worth also recognizing that intimidation of judges has existed to some extent, I think, in the background for much of the country's history.
I think that's an excellent point. It's this is part of the American dynamic, I suppose, but it also is part, I think, of separation of powers. And if separation of powers is functioning, things end up being subject to checks and balances, so that in fact there'll be pushback. There'll actually be a resistance. The one thing the framers feared the most was having a faction take over all 3 branches. I will leave it to you to determine if that has ever happened in American history.
Well, and to that point, and then I want to switch a little bit, and I want to ask Judge Childs something, but I want to just follow up on this last point you made, because there was a piece published yesterday by Professor McConnell from Stanford, who's a conservative scholar, and he was saying that one of the things, when you go back to the founding, the Congress really thought the main check on the founders thought that the main check on the executive would be Congress. That was sort of, it's not that they didn't want the judiciary to be independent, and there was a lot of debate, as we've said, about judicial review and so on, but the idea was Congress would really be the main branch, and that's why they're in Article 1, right? I mean, they're the ones who are supposed to, guarantee the Republican form of government, and then the president's is Article 2, and then the judges are Article 3. But what Professor McConnell was saying is that at this point, Congress does not do that. Congress is a rubber stamp, and in that particular event, the courts become the only way to push back. And it puts the courts in a role that they really are not comfortable being in. It's not really what they were set up to do. And as Michael said earlier, judges aren't politicians. And so there's an anomaly going on in terms of what the original conception of the Constitution was. And I thought that was a really useful point. I want to turn to Judge Childs. And one of the reasons we wanted her here to be part of this panel is that she's still a sitting judge, and she sits in DC. And a lot of the current controversy has been there. It's been in front of DC district judges, and it's come up to her court. So obviously she can't talk about cases that are still pending. But what you can talk about is what's happened to you as a human being, right? Being in that particular spot.
Certainly.
Yeah.
Well, back to Chief Justice Roberts' 2024 year-end report, what he indicated was 4 areas of illegitimate activity in which he chastised is violence, intimidation, disinformation, and threats to defy lawfully entered judgments. So I've served as a state trial judge and as a federal trial judge. I'm used to the high-profile cases. You all are lawyers. You fight very zealously for your clients, but you also know there's going to be winners and losers. There's going to be an appropriate vehicle to challenge that, and that would be the appellate process. I've never minded that. You can have a motion for reconsideration, which I welcome because I'd rather reverse myself than the appellate court at that time as a trial judge. But then you also have that appellate process in which we expect you to go through very thoroughly, continually to zealously represent your clients. What we do not expect is that with respect to our judicial decisions, you try to threaten or intimidate us. And let me tell you the forms of threats and intimidations that are going on now. Some of you may have heard a lot about the pizzas. Well, I've had 7 come to my house. And it came right after I was on the DC circuit, just ruling on a case. And I didn't pay much attention to it. My daughter was at the beach that weekend, and I've never ordered pizza, by the way, to my home. And I just thought she didn't put the right address in because she might have had it on one of her apps or something. She said she didn't do anything. And we said, okay, nobody's ordered pizza. You can take it back. So then it just came to my mind, and I was in a federal judge's meeting, and I just kind of mentioned it, at the beginning of the call when we're all just talking about what's going on. And I didn't think anything of it. And then within a week later, we're getting an alert from the marshals to say, watch pizzas coming to your house. So, we can't prove where it's coming from, but it's very much coordinated and coincidental to rulings. And so what's gotten worse about them, the whole intimidation factor is to say, we know where you live. Now, I'm on the DC circuit, but I live in South Carolina, and this came to my South Carolina home. The other thing is coming in the name of our children. One of mine came in the name of our South Carolina marshal. And what was really bad is you heard of Esther Salas, who's a judge on the District Court of New Jersey, and a disgruntled lawyer shot her only child, son, Daniel Anderall, shot her husband. He's had over 15 surgeries. And there were a lot of pizzas delivered in Daniel Anderall's name. We also have the situation where they're swatting. Someone will call the police and act like there's something going on at a particular judge's house. A lot of times your children may be home. You tell them not to answer the door. And then they send out basically a SWAT team, and nothing really happened, in that regard. We also found out that there's a most wanted poster that was on the walls of Congress, pictures of individual judges who had ruled against the administration to say, we're ready to impeach you, the most wanted list, so to speak. Thank you, Federal Bar Association, because recently, and I believe it's within the last 2 or 3 weeks, you wrote Congress and said this is not acceptable. So they took it down. But the picture had made its way to the internet. You've got judges' children's being blown up on social media, also spouses, in that regard. And so you've got all of those issues going on too. Luckily, some of the things that we're doing to help ourselves is right now I'm speaking not about a case, but our codes of conduct do allow us to speak out on the fair administration of justice or when there's challenges in that regard. So I'm hopeful that some of my colleagues will feel comfortable. But as you've indicated, we're not political, so we're not used to speaking out. We write our comments and our commentary in our opinions. This is not what we do. But I felt like, this is important to explain to people what's really happening as somebody who's actually experienced it. It calls for much more resources from judicial security because we have to pull the marshals off of whatever else they might be doing to protect us, and have drive-bys with marshals and local police officers coming to our houses as well. Luckily, we've got through the administrative office of the court a delete me, where we're trying to get ourselves off the internet. And Judge Esther Salas, to her credit, is relentless in going around the country and being on various shows. And she helped us with a bipartisan bill for the Daniel Anderall Act, in which we delete our personally identifiable information off the internet. And we're trying to get that done on the state side as well. There are also several states now trying to go with bipartisan legislation to have more security for local judges, even things as how you enter the courthouse, where you're just not coming in with the regular citizens or litigants and things of that nature. But it's a very real issue, and it has not stopped. Where it's really affecting everybody is the integrity and independence of the judiciary so that the public has a fair perception to respect our rulings and respect us as a co-equal branch of government and an institution.
Yeah. Well, it's stunning. And, I started my judicial career in the 1980s. And one of the things that I always think about is in my entire career, which is 37 years, I had one credible death threat. And it was in a family law case. It was somebody who was unhappy with a custody order. And that was it. And I had a case in not that long ago, about 10 years ago, that was, I'm sorry, now it's 20 years ago, that was extraordinarily controversial. It was all over the news in California. It was even in the national news and even international news. It was such a controversial case. And I got maybe in the entire aftermath of the case, I got 200 or 300 emails, maybe.
And I will say
Yeah.
too, from the statistics from the U.S. Marshals, there might have been about 400 judicial threats last year. We're past that number now.
Yeah.
Can I?
Yes,
I
go.
just want to share.
Yeah.
A couple thoughts, if it's
Right.
okay. So I think these instances are extremely important to keep in mind. I want to take the risk of providing an overarching theory. After all, I'm an academic, so I have to pretend to be one. But imagine you have an administration that regards everything as political. And I mean everything is political. That also includes thinking, therefore, judges are just political, like things we could move around a chessboard. And so not a surprise that people would say, oh, let's go after them in the political process. And we want judges, not necessarily who are going to reason well, but judges who will simply give us the outcomes we want. And I don't know what principle explains differences in outcomes in some of these Supreme Court cases, but I think we're hard pressed sometimes because the court has not been consistent at all. The second point I just want to make, for whatever it's worth, is sharing a statistic. There's a Stanford political scientist, some of you may have read this, that found that over 90% of the cases against the Trump administration in the lower courts have ruled against the Trump administration. But the Supreme Court has ruled for the Trump administration over 90% of the time. I don't know of any other era in American history where you have ever seen that kind of dissonance or disjuncture between the Supreme Court and the lower court. And I want to suggest, as my last thought here, that statistic also may give us an idea of some of the reasons why we get these threats against lower court judges. Because if you've got that kind of disparity, it's going to be understood by many people as just political. So if the Supreme Court is right 93% of the time, the others are wrong 93% of the time, what's the solution? Get rid of these people that are wrong all the time. And so I think the court itself has not been really kind to lower courts, in my opinion. And the very last thing I would say, just to introduce this whole concept, has to do with legal ethics, because we also have lawyers showing up in court, oftentimes defending these things, that demonstrate such disrespect to courts. I have never seen that before. And we have one case, well-publicized case, involving a judge who granted a stay, who granted or actually found in contempt a number of administration lawyers. The DC Circuit stayed that. The odd thing is it continues to be stayed, and there's not been any subsequent action. And that is another factor which I think leaves these lower court judges just dangling and vulnerable.
Yeah, I won't ask Judge Childs to comment on that for obvious reasons, but this really tees up the last question I wanted to ask all of you before we engage with our audience. I think it was very useful going back and looking at the history, because we have 250 years of history, and some of these things aren't new. We've had political attacks on judges, we've had threats against judges, we've had eras where the courts were being very vigorously attacked by the executive branch. So that's all history. But is this era unique? And if so, how? I think I'd ask all of you that question. Marin, what do you want to start with that?
Sure. It's obviously a hard question to think about. So, how unique is the particular moment? So maybe I'll just say this. This doesn't. It seems like, I mean, given the history that we've just described, in some ways, this moment is not particularly unique, right? As we've just said, there have always been threats against judges. I think part of what we're seeing, there are a few things that are different, though, about the moment. And one is just, I think, the magnitude of the threats. This is not particularly insightful to say this, but I think it's still worth recognizing. You think about the role of social media in all of this. So we've been talking about impeachments here. The reason we started this whole conversation a few months ago and thought it would be helpful to have this panel was thinking about articles of impeachment that have been introduced against certain judges who've been ruling against the administration. If you look right now on Twitter, there are folks within the House who have been tweeting about these articles and using language that is quite incendiary, calling judges, predators or activists, things like that, of course, to discredit them. And these various tweets, I was just looking at some of them recently. So some of them have received something on the order of 25,000 likes. They've been viewed something like 9 million times. Right. And I think that just poses a huge threat to the judiciary, in part because, as we've been saying, judges are somewhat constrained in what they can say in response, and also just who has that kind of megaphone, right? I mean, not the FJC, not the AO. So I think that right there, just to point to one factor, is part of what makes this dynamic so complicated and difficult to combat. I think it's worth talking about responses that we can all be taking up against these sorts of things. But I think that's one thing that makes this particular moment feel different from what we've seen before. It's the magnitude.
I'd also have to say the volume. Professor Gerhardt, you mentioned that 21 impeachments. Right. There were, I think, more than 21 people on that poster.
Yeah.
And we're just in July. And so when you just think about that you're talking about over a course of, several decades, that many people. And so then just that concentration of it in terms of the volume in that regard. I'd also say, yes, there have been death threats, particularly civil rights era, other eras. Yes, there have been people called out, embarrassed, chastised as judges sitting on the bench. And, again, some of that you get used to. But it's the sheer volume in such a short period of time that all of this is occurring in.
I think that's a very important point. Also, I think every era is unique. And I think that, although I'll now contradict myself, I also think that we can learn from the past, and the past obviously sometimes needs to be understood to better understand the present and the possibility of a future. I had two clerkships. The first was with a federal district judge, and I picked this out for personal reasons. I wanted to work for a judge who had been very active in civil rights. And I clerked for a judge who was the second judge in the United States to desegregate a major metropolitan area. After he did that, the next few decades he had were filled with threats. His car was blown up. He was ostracized, and that became the nature of his business. And because I was there experiencing some of this. For example, one day somebody walked into the federal district court, us, and tried to file something. But it's a mistake. But I was about to say, "Oh, go down to the clerk's office," but instead security showed up because they couldn't be sure, why this person was up there. I want to just also maybe suggest the possibility of a couple different solutions, or at least hopes.
We're going next.
Yeah, that's it. One is, and this is something I just say all the time, so forgive me. I think we've got to do a better job in inculcating within our students and young lawyers and lawyers throughout their lives an appreciation for legal ethics. I think that that has degraded to such a degree that I'm not sure we've ever experienced such a degradation before. And there are various ways of doing it, but we've got to do that. Part of the problem is people who should not be lawyers and frankly shouldn't be judges are not ethical people. And that is in tension with the rule of law. The other thing I think that's extremely important is public education, which you've referred to. You and I have done programs at the National Constitution Center in Philadelphia, which is a great place. This is exactly the kind of event I think that is needed to inform and educate people. And last but not least, I think most people are just unaware of all this and maybe don't even care because they don't know how it affects them. So I think one thing that's important is to be able to demonstrate to people why these threats are going to dilute the federal judiciary, which is here in part to ensure the protection of the rights of everyone.
Yeah, well, all good points. I mean, I'm going to just add a couple of things. So for sure, we need to do a better job of telling people what a precious role the having an independent judiciary is in a democracy. You know, we can, in some of the speaking I've been doing lately, I've talked about, well, you know, you could live in Turkey, you could live in Hungary, you could live in Poland, you can live in places where they had democratic governments and authoritarian leaders that successfully attacked and degraded the judiciary. And those countries are not democratic anymore. Poland is trying to come back, but the others are, you would not characterize them as being democratic in any way. And the way that a major way they got there was that the government degraded the judiciary. So somehow getting that out, I think we need to do a much better job of how we explain things. We use jargon too readily. What's the rule of law? What is that? What is judicial independence? What does it actually mean? You know, and we've had good expressions of it today. I mean, you know, you do not make decisions based on power. You make decisions based on rules. And you know, if you own a piece of property and you've got title to it, then your next door neighbor can't come and take it from you. You know, and there's a means of enforcing that right. That's the rule of law. But I mean, getting into that and talking about things like due process, but nobody knows what due process means either, unless they're lawyers, you know. So you talk about, okay, well, that means you have a right to be heard. You have a right to make your argument, you know, and just really thinking about who our audience is and how to talk to them, maybe talk to them through better media than we have been using. And then the last thing I'd say is, I think, and we're starting to see this, and I think some of the more prominent cases that you've read about, judges are starting to speak more through their opinions about these issues. They aren't just deciding the case. You know, they're not just writing a bunch of legalese and deciding the case. So, I mean, the ones I always encourage people to read Judge Wilkinson's opinion in the Kimar Abrego Garcia case.
Great case.
I mean, you know, Judge Wilkinson is, you know, if you were going to list all the federal judges in the country and say who were the most conservative judges in the country, he would be in your list. You know, he'd be high up on that list. And this is a brilliant opinion about the importance of the rule of law. And it's just kind of written in a very relatable way. And I think more judges are starting to do that. Some of the judges in Maryland who've been doing the immigration cases have been taking the extra time and trying to explain, no, wait a minute, this is what the government's obligation is. This is what the government failed to do. This is why this is a bad thing. And to your point about ethics, I used to teach ethics to both lawyers and judges. And one of the things that always kind of made my heart sink is when people would say, well, you know, how do I avoid getting in trouble? You know, what do I have to do to avoid getting disbarred? Or what do I have to do to avoid getting a complaint? You know, rather than what should I be doing? You know, what are the aspirational values of this profession I'm part of, and how do I live up to them? And I continue to struggle with that. But I think that's another thing that we can do in terms of leadership about this issue, because I agree with you, ethics is really important. And I'm not slamming anybody, and this is not a political comment. I think what happened to the Supreme Court around ethics did a tremendous amount of damage.
Yeah.
Because people don't distinguish. They don't distinguish between the Supreme Court and trial courts and state courts and traffic courts.
Well, a judge is a judge,
Yeah,
right?
a judge is a judge. So I think that's a really important thing. Anyone want to
Oh.
add?
You might want to take the
Yeah,
questions.
I think we're ready for questions. Yes, sir.
Oh, what a good question.
Professors.
Although apparently Justice Alito doesn't like the phrase shadow.
Emergency docket.
Um, according to one statistic, within the last 10 weeks, there have been 7 rulings from the Supreme Court through the shadow docket. I assume everybody understands that one aspect of the shadow docket is that there's no argument, no briefing. It's done very quickly, basically in the shadows, which is why you get that name. And I would just respectfully disagree with Justice Alito and say that name seems pretty apt to me. After all, some of these cases are important. And the shadow docket is supposed to be designed to deal with more like procedural things, trying to managing a case, not essentially issue rulings, which are pretty much stacking the deck when it comes around to decisions on the merits. And that's my concern, is that the shadow docket is being abused.
And you don't always know who's voted.
Well, the thing is, for example, with this recent decision about Department of Education, the court itself issued no opinion.
Right, we get a dissent.
We got a vigorous dissent. Yeah.
Yeah, maybe I'll just say, I mean, right, quite a bit has been said about the shadow docket. I'll just add, I think at this particular moment in time, it seems quite unfortunate to have decisions that are of such importance without having reasons behind them. I mean, we all know, of course, when it comes to these kinds of shadow docket rulings, right, they're happening quite quickly and without full briefing and so on. And so the justices will often feel constrained and may not want to issue something that is precedential. But I think particularly in the case that we just had come down, when you have a lengthy dissent of that sort and you don't have reason given by the majority, I think it just, in this particular moment especially, creates real concerns. And I hope the court tries to avoid that in the future.
I said a minute ago, we don't have a good definition of the rule of law that works for lay people. So one thing about the rule of law is process. In other words, you get a chance to make your arguments, respond to the arguments that are made, and there's a process. And another part of it, which I didn't mention, but I think is part of it, is transparency. So you get some explanation of why the court made the decision that it did, and the better you do at explaining it, the more likely it is the ruling will be accepted. And with the emergency docket, you have neither any indication of how much process there was or what the process was, and you have no transparency. Unless you are, inferring it from the dissents, you can sort of imagine, well, what was the conversation? I mean, did Justice Sotomayor and Justice Alito actually argue about this? I mean, what actually happened? We don't know, and we're not going to know. And, I hate to be critical, but, we have almost 400 million people in this country. You know how many merits cases the Supreme Court had last year? So I think a little bit north of 60.
It's shrinking.
Yeah, I mean, 60. And we've got all of our, yes, it would be really hard for them to take a lot more than that. But I mean, I think when you juxtapose that with the kinds of decisions that are being made without transparency and without visible process, I think that really does undermine public confidence, in my opinion.
I think it raises, at least for me, a question I would like to ask the Chief Justice, because I think the Chief Justice, I'm not Chief Justice. I never will be Chief Justice. I understand that, and I can live with it. And believe me, the nation can live with it. But I think when he undermines his own efforts to protect the integrity of the Supreme Court, when he allows the practice that the court is pursuing with the shadow docket, because that looks like judicial fiat. We learned in first year law school, ipse dixit. No, that's basically what the court's saying. The court's saying, do this because we said so.
Yeah.
I don't think anybody should be very comfortable with that. I think if they take as few as 60 to 70 cases a year to write the merits, and with all the law clerks and other help they have, I think they can manage a few other opinions, especially because the court's legitimacy depends on it.
Yeah. Let's take another question. Yes, sir.
Yeah, let me see if I can repeat the question for those who are virtual, and I'll paraphrase it. Isn't the sense that people don't
they don't really see what's happening in terms of the harm that's being done to the independence of the judiciary, a symptom of perhaps of people just not caring about whether the government that we currently have is worth preserving, that there's a sense of disenchantment with the whole project and burnout about the entire project. Is that the essence of your question? Yeah. Okay.
I'm digging a hole for myself. I just want everybody to understand that. But at the risk of doing that, I think another contributing factor to this is the degradation of education. There's a lot of disdain and contempt for education, particularly public education. And I think, unfortunately, for a lot of people, they have not been educated by the Constitution. And they really don't know what's going on, as Judge Fogel said, but I think in part because they've been misinformed. They catch something on the news or some political sort of theme that they've heard about, and that informs their judgment. But keep in mind that one of the things that concerned the framers the most was to ensure, what concerned them a great deal was hoping that the American people would become educated. Remember, the framers were children of the Enlightenment, and they thought the entire republic depended on that. And in an era of disinformation, which is what we're living in part, it cuts it right at the heart of that. And I think it also helps frame and shape and perhaps provide some motivation for what you just described. People want to burn it down, but I think if you ask them, what do you want to burn down? They wouldn't necessarily be able to give you an intelligent answer or informed answer about that. They like the presidency fine when it's their president. They like Congress fine when it's their Congress. And they like Supreme Court fine when it rules how they like. But they don't know what EPA does. They don't know what a lot of these FCC, FTC, and all the rest do. But they want to burn it all down. And I would have more respect for that. Well, let me say, first of all, I grew up in Alabama, Jewish in the 1960s. I understand what burning things down looks like. I have seen it. I understand that. But it's usually done by a mob and not a particularly bright one. But it's still dangerous. And I think that's part of what challenges us right now.
Sure. I mean, so I guess I'll be measured here. I'm no sociologist, so I feel like I have to stick within my jurisdiction here, but I can maybe just tentatively observe it. So I think it does seem like this is part of a larger trend, a larger problem. And I would throw into that anti-elite sentiment, anti-establishment sentiment. I mean, we've seen that growing fairly recently. And I mean, one way to understand these various threats of impeachment is that it's good politics for someone. I mean, that's the part that I find quite chilling, right? That the people who are picking these fights are picking them deliberately because they think it's good for them. And that tells you, I think, a lot about the kind of general sentiment out there. I mean, I think many of us in the room see these kinds of threats and think, my God, how could you lodge these sorts of things against some of the most well-respected judges of our time? And, for others, this is blood sport. And I don't have solutions for that. I think that's a much deeper problem.
You feel comfortable saying anything?
I would just say that we need civics education. I mean, you've mentioned that before, but it really does start in the elementary schools and forward, and then that has been taken out of a lot of the schools.
That's right.
And so that's a problem.
Well, and I'll hold that for one. I just want to add one more thing because it goes to something that Professor Levy just said. People want to be entertained.
Yep.
Right. And they like punchy stuff. I mean, I've been trying to understand media better, and the media we all grew up with up here, I mean, was legacy media, right? Newspapers and, things like that. Uncle Walter Cronkite even, it's like, and it's like, we didn't do TikTok. We didn't listen to podcasts where you would get things in 30-second bites, but that's the way a lot of people get their news. And so, you're talking about, yeah, let's impeach that guy, told the president what he couldn't do. That is the news story right there. I will comment on this, and I'm going to be very careful. I am not commenting on the merits of the case, even though I could if I wanted to, but I'm not. So the judge who got arrested in Wisconsin.
Yeah.
So I don't know whether she committed a crime or not. That's something that will be determined. I'm not making any assumptions about that. But the way that it was staged was right to Michael's point. It was, you had the attorney general holding a press conference. You had the FBI director holding a press conference. I mean, they made it into the biggest crime since, somebody, started the Chicago fire or something, and I mean, I think that was all deliberate, because it grabbed the news. It was a punchy kind of thing, judge releases illegal immigrant, blah, 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 and I think there is this sense of wanting to be entertained that's part of what's getting in the way here. Yeah.
Well, that's a great intro for my last comment.
Yeah.
As a parent of 3 men, part of what I've had to do is go to a lot of movies, and I become an expert on Batman. And when you were asking your question about people wanting to burn it all down, I was remembering what I think is one of the great quotes from the Batman series. You can learn things from that. And there's a point at which in The Dark Knight, Alfred says to Bruce Wayne, by the way, I think we all know he's Batman. Anyway, I'm sorry if I just, but Alfred says to Bruce Wayne, he says, some people just want to see the world burn. And I think there's a lot of truth to that. So when you say burn it all down, I think some people would rather destroy something than actually either help build it or help maintain it.
You had a question, ma'am. Go ahead.
Yes, thank you so much. On the idea of this is politically expedient for somebody, and kind of bringing it back to this history of politically motivated threats against the judiciary, has there historically been a political balance? Someone's in power, the other party launches these threats, or has it been less even Stevens and more unidirectional against, progressive policy or perceived progressive judges? And if so, does that suggest that the solution, does that inform the solution? Does it inform the target audience?
It's a great question.
Yeah. So
Yeah.
how common, and I want to try to paraphrase the question. So if I miss it, please tell me. But, how often have we been in a situation where it's all government is stacked in one direction, all 3 branches, and everything's been copacetic among them, versus times when there have been divisions among the branches and there have been conflicts among the branches, or you have the branches being all aligned and going after people who are seen as outliers?
Right now, I think we can see a conservative movement
Right.
against, we see it in the halls of Congress, right? See that list.
Yeah.
And it's a conservative political movement against perceived progressive policies or perceived progressive judges. Is it throughout history? Has that been the trend when it comes to politically motivated threats, or has it just kind of flip-flopped like politicians?
All right. So, and I'll try again. Sorry. I'm doing this here. So
It's a really good question. I want to do it justice. So has it all been conservative political folks going after progressives who were seen as outliers, or has the shoe been on the other foot? Have there been times in the past where progressive political branches have gone after conservative judges? I mean, I think I know the answer, and I think, but either one of you, I mean,
Sure. Maybe if it's okay.
yeah, go ahead.
I'll screw it up. Sure.
Yeah.
Yeah. No. So like all your law professors would have done, I'm going to dodge the question. No. I'll kind of rephrase it or rethink it. I think it's a great question, but I think the idea of what's liberal and what's conservative and what's progressive have themselves changed over time. So it becomes very difficult to put it into those terms. For example, we all know President Abraham Lincoln was in office during the Civil War, and he did a lot of very important things, and he's credited, along with the Army, with actually preserving the Union. Now, a lot of people look at him and think, oh, he was progressive, he was liberal. But in fact, at the time, he was the conservative because he was trying to maintain the republic. He was trying to protect it. He was trying to protect the status quo. And it was the radicals, the Confederates, I'm not sure I'd use the word liberal, who were the ones complaining. So depending on the era, you may have some difficulties thinking it's progressive versus non-progressive. A lot depends on what progressive means. And I think that's part of but I think you make a really good point. I think they're just political movements that build up to advance agendas. And they can come from the left or the right, or just, so I don't think any one party necessarily controls it, but I do think it's a dynamic that's getting worse over time.
Can I actually just add one?
Go ahead. Hang on one sec.
Just one quick thought on that. I mean, it's a terrific question. I think one of the challenges in answering it is that so much is going to be in the eye of the beholder. So, I mean, one point I think that's worth observing, if we go back to 2024, I think it was AOC who introduced articles of impeachment against Justice Alito and Justice Thomas. This was in the wake of the kind of ethics concerns that were bubbling up at the Supreme Court. You know, I think we can look back at that decision today and think perhaps that was problematic. You know, some might say not. But, you know, if we think about, does that help to open the door to the kinds of threats of impeachment that we see now, perhaps? So I do think, I mean, we have seen examples on both sides. There will just be, of course, debate about whether it was warranted or not. But I do think, going back to our earlier conversation, what we're seeing now really is just so much bigger than what we've seen before.
Yes, it's the magnitude, the volume, as Judge Childs said. Yeah, I mean, I always think of Senator Schumer's attacks on Justices Alito and Thomas, you know, that at the time, and I remember thinking, wow, you know, that's maybe not such a good idea. But anyway, and when I talk to conservatives, they always bring that up. So I want to get to your question. Go ahead.
That's a really good ending question because I see we're running out of time.
But so are we in a constitutional crisis? And what does that phrase mean to each of us? So I don't know if Judge Childs is going to feel free to comment, but I'll start. No. Yes, she takes her judicial ethics seriously. So let's go with Professor Levy instead.
Like, are you sure you don't want to pull us off now?
Time for the hook. Yeah.
I'm sure you can answer that. And then we have one more question for you before we end.
Okay.
Oh gosh, in 30 seconds or less, right? So maybe I'll offer a little bit of a dodge too. It's a great question, but I think I'm sympathetic to those who have said it's not clear that in some ways is the most helpful question, right? I mean, when we talk about constitutional crisis, that assumes that it's like a binary, like we're in it or we're not. I think anyone who's observing the state of the judiciary right now would say, you know, we're seeing a kind of contestation, a sort of series of confrontations that we have not quite seen like this before. And obviously we have an executive branch that, if you know, perhaps not outright defying court orders, has been inching in that direction. I think it's a moment of grave concern, whether we're in an official crisis or not. That's what I would say to that, I suppose.
No, I think I certainly agree with that. So let me define two different concepts, which sometimes get collapsed together. One is a constitutional conflict. And a constitutional conflict is, at least in my opinion, a disagreement or conflict between one branch and another. So when the president and Congress are butting heads over an issue of constitutional law or the Constitution, that's a constitutional conflict. So when a democratically led Congress goes after a Republican president, you could say, oh, that's a constitutional conflict. But it's not a crisis. I think constitutional crisis are words that get overused. I think I agree with Marin 110% on that, because I think ultimately a constitutional crisis is when it's not when the parties can't agree whether the Constitution has a solution. It arises when the contending parties disregard the Constitution or the Constitution doesn't have an answer. And I think that's a crisis. Right now, I think the Constitution does have some answers. The question just becomes to what extent can we get the people who swear an oath to follow it?
I think we don't, I don't think we know yet. I'm worried, but I'm also an optimist. So, I'm trying to hold both of those things at the same time. So.
And Judge Fogel, I was hoping to close us out, you might address what happened in Maryland.
Yeah.
to
Which
them there.
thing was suing the judges or something else?
Yes. this-
Suing the judges. Okay, so does everybody know this story? So the District of Maryland, which I think is almost entirely made up of Democratic appointees, when this is relevant to the analysis, has a rule that if you file a habeas petition that involving immigration, that you cannot deport the alien until for 48 hours, so that the judges can review the papers and decide how they're going to react to the petition. That is a court rule that the District of Maryland has. The Justice Department believes that rule is an illegal injunction. That what the court has done by rule is they have issued a stay of deportation, maybe only for 48 hours, but they've issued a stay for 48 hours without any consideration of the individual consequences, without any consideration of the equities of that particular alien's case, and that exceeds the court's power. So that's what the dispute is. The other thing that's interesting about the case is the way the Justice Department has approached it. And I always get geeky. That's because I've been working in academia for 6 years now. So I'm sorry, apologize for the geekiness. But there is some precedent, actually. There was a case, you may remember, that it was a same-sex marriage trial that Judge Von Walker, who was my colleague, had in San Francisco, and he wanted to televise it. And that was in violation of national policy, but our court had some leeway under the pilot project that was in place at the time. And so we had a court rule that would have allowed him to broadcast that case. And the parties didn't like that court rule. They said it violated their rights and the rule wasn't adopted properly and so on and so forth. So they petitioned directly to the Supreme Court and they got a stay. And in the course of its opinion around the stay, the court said, we're granting the stay because if an appropriate case were brought, the petitioners would likely prevail. So they did a kind of classic weighing, and they said that the appropriate action was a writ of mandamus. Okay, this is where the geeky part comes in. Okay, so what you would normally do if you think a court rule is illegal or improper or exceeds the powers of the court, you go to the Fourth Circuit or you go to the Supreme Court and you file a writ of mandamus and you say the court is acting in excess of its jurisdiction. That's what writs of mandamus are for. And what they did instead, what DOJ did instead, is they named each of the judges of the District of Maryland by name as a defendant. They sued them, at least they didn't sue them in their personal capacities, but they sued each one of them with the very obvious intention of forcing all of them to recuse themselves because they were defendants in the case. And then they asked for the appointment of another district judge from outside Maryland to rule on their lawsuit. So, the way I reacted to this, having been a district judge for a long time, is okay. So I'm holding court in San Jose where I used to sit, and somebody doesn't like what I'm doing, and so they sue everybody so a judge in Sacramento is going to decide whether I'm making the right ruling or not. And that's just wacky, but it goes back to the performative art that we were talking about before.
Yeah, I would just add, right, to kind of close the loop on this.
Yeah.
It seems like it just pulls the judges into an adversarial posture, right? That's clearly part of the intention. It's to say, right, judges are not these neutral arbiters. They are in fact our opponents. And no better way to do that in effect than to make them defendants in a lawsuit, which is, completely inappropriate.
I would just add that what we're learning has to do with all the ways in which you can frustrate federal judges.
And former federal judge.
But frustrate in a very hurtful way. We've had suggestions that district courts should be abolished. That might be consistent with Supreme Court precedent. Judge loses if the judge has no court, judge has no jurisdiction, you know. And so there are a lot of different ideas being floated around. And what we're experiencing to some extent is an administration that's looking for ways of knocking out the judges it doesn't like, trying to find the ones it does, which is a reaffirmation of its overall view that everything's political. Let's get rid of the people that we don't like because they're not giving us the decisions politically we'd like. We'll find somebody else we do like. So it has everything to do with undermining the rule of law. And it is ultimately the kind of threat I think the separation of powers was meant to prevent.
Thank you. Well, I want to thank each of you for your time and your talent, and I ask our audience to help me thank our panelists. And to close us out today, I would like to bring up the president of ABOTA, Tom Vertitas, to give us the last word and get us to the reception.
And I would be remiss if I didn't say thank you for everyone attending, including Lem Howell, one of my superhero friends. Thank you, Lem, for being here today. I'm the president of the Washington chapter of ABOTA, and Judge Childs and Professor Gerhardt, you said something that's very important and something we take very seriously here. Our three tenets as an organization are protecting the Seventh Amendment right to jury trial, independence of the judiciary, and promoting civility within the practice. And that's what all of you are saying. So we are in the high schools teaching civility, and we are in the law school. I'm sorry, we're in the high schools teaching civics, and we're in the law schools teaching civility. And many of our what's going on with the attacks on the judiciary. We've created rapid response teams. We're actually, with Mike Wampold here, who is a past ABOTA president, who is the current Federal Bar Association president, we're actually working on social media videos to try to move into the age of 20-second TikToks on really trying to address and recognize our judges for what they are. They're heroes and they're public servants that do something that's essential to make sure our country moves forward. So I want to make sure that everyone knows we put away our chairs, right, Robin? And then we head down to the jury assembly so that we can continue to enjoy conversation with a little bit of beverage. So again, thank you for traveling so far. I really personally enjoyed, and I know everyone else did, enjoyed our time here today. Thank you, everyone.